Hello, this is Matt on the Moon Lambeau channel. It is no longer a question. The Chamber of Digital Commerce will be filing an amicus brief in the SEC v. Ripple case. Now, technically, as I reported in a video literally yesterday, technically the Chamber of Digital Commerce did file something in August of last year, but they didn't follow the local rules, and so it was just broomed away, and we haven't seen anything since then, other than Perianne Boring, who is the founder and president or CEO, whatever her title is. She's the one leading the Chamber of Digital Commerce. And she's been stating, hey, can't speak on this right now, but, which isn't technically true, like there's no legal requirement, she just doesn't want to, but she said, hey, we are going to be filing an amicus brief in the SEC versus Ripple case, and we're really down to the wire here and hadn't seen anything just yet. And then happens to be the case that one day after I made a video highlighting that there was evidence that they were probably going to move forward because they had in the past and it would be weird not to, the very next day, here we have Perianne Boring of the Chamber of Digital Commerce dropping a hint, but it ended up being a little bit more than a hint, and I'm pretty sure it's a damn accident. But I'll explain what I mean by that. But it's about 100% certainty that she is going to be filing this thing on behalf of the Chamber of Digital Commerce. And also, Attorney John Deaton has firmly stated in brand new comments that Bill Hinman did in fact break the law. Now, up to this point, regarding Bill Hinman and all of his happenings with Simpson Thacher and this and that, Attorney Deaton has certainly called for investigation, said, hey, it looks like there might be something here worth looking into, but, appearances of impropriety at a minimum. But now Attorney John Deaton is full on stating unequivocally that Bill Hinman broke the law in what he had to do regarding specifically his former law firm Simpson Thacher, which he ended up going back to, being a member of the Enterprise Ethereum Alliance, while working at the SEC and pushing for things that would benefit explicitly Simpson Thacher as a member of the Enterprise Ethereum Alliance. So I'm going to break down all this, but before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, before getting into those topics, I wanted to take just a moment to highlight something that just feels good to know is true. If you look at your screen, you already see what I'm getting at right here. Hashtag Gary Gensler resign today was trending on Twitter. You gotta love this. People hate Gary Gensler so damn much, Kim Jong-Gensler, that hashtag Gary Gensler resign is trending on Twitter. Shout out to XRP community member JV for highlighting this. It was heavily circulated throughout the XRP community member on Twitter, and I felt I'd be remiss if I didn't at least take just a moment in this latest Moon Lambeau Hot Jam to highlight that, because as far as I'm concerned, that's pretty damn awesome sauce. So into this topic, though, the Chamber of Digital Commerce, which is supposed to represent all of crypto, right? Well, I've gotten the sense, and I mentioned this yesterday, so I'll be brief on this, but I've gotten the sense that the Chamber of Digital Commerce, they understand the gravity of the situation regarding the SEC v. Ripple case. They understand that if things don't go well for XRP, then pretty much every altcoin under the sun is effed. They are... Because, look, what would not be a security? If XRP is a security, what's not a security? By the standards set forth by the SEC, if their arguments actually win. So I think that Perianne Boring and her Chamber of Digital Commerce, I think they get it. But on the flip side, they haven't been publicly vocal about it, and they're hiding behind this guise of, well, we can't speak because we haven't filed the amicus brief. Well, there's no legal standard for that. They're just choosing not to. And I suspect that it's in part, as I articulated yesterday, because they probably got a whole mess of Bitcoin maxi trolls out there that support them. That's probably, and they're just noisy. Now, mind you, most people are not that vitriolic and toxic in the world of crypto, but the small percentage of humans who are, they're the noisiest. The small brain humans are the noisiest humans. And then it makes it feel like they're all encompassing. But it's just an illusion. They're not all encompassing. But it makes me wonder, I'm just speculating here, that perhaps that's why, because God forbid somebody be public and extremely vocal about defending XRP and XRP holders. You don't have to defend Ripple even. And I don't think they're going to defend Ripple specifically. But here's the hint that was dropped by Perianne Boring. It just says, coming soon, with this little eyeball emoji and this picture that she took and uploaded that just says Exhibit A. Now you might think, it just says Exhibit A. Well, how do we know what the hell this is? Well, if you go to this tweet from XRP Crypto Wolf, XRP community member, he points it out quite eloquently. He says, anyone else see Brad Garlinghouse right above Exhibit? Perian and Digital Chamber finally came through for the XRP community and Ripple. Right, exactly. So I don't know that this has actually been filed, but it's there. It's in front of us. And here's what's being discussed here. I'll actually pull this up. I don't know that it's going to even be remotely legible on your screen, but from where I'm sitting, I can read this. If you look where my mouse is, it's BRADLEY, and then the rest, this looks a little bit more smudgy to me, but you can still see it's like GAR. And if it's, to be honest with you, if it's a little bit more zoomed out than what I'm showing you right here, it's actually even easier to read. So there's a sweet spot where if it's too far out, you can't tell. If it's too zoomed in, it's super duper hard to tell. But if it was out a little bit further, I just don't have it zoomed properly for this particular Moon Lambo Hot Jam, but it does say Bradley Garlinghouse. There is no question that says Bradley Garlinghouse. So that is indeed what this is, and it's good to see it. Now, upon discovering this, attorney Jeremy Hogan retweeted that from Perian Boring, and he wrote, the chamber is wading into the Ripple v. SEC case. Expect something similar to what it filed in the Telegram case, and the argument is that although the sale of XRP might have been as a security, the token is not inherently a security. Similar to Jay Deaton, just not as compelling. So that's the tweet. And I don't know why we shouldn't expect something like that, frankly. If you go through what was stated in the Telegram case, and I have, not that I've literally read all of that, but I've seen it summarized by a lot of people that I respect and trust within the XRP community, including attorneys within the XRP community. And it does seem pretty damn clear that the thrust of the argument is basically what John Deaton's saying. And so to have another party that's amicus stating the same damn thing, but no, for real, John Deaton's right, and here's why. To me, that seems very powerful. It seems very useful. So if they're coming in, even though they haven't been as articulate, or well, let me say, verbose publicly about this, okay, fine, I'll let it go, because looks like they just want to, appease the maxis, perhaps. I don't know, I'm speculating, but still, even if that's the case, okay, fine. As long as they come through, at least in court, then I'll accept that, right? you got the Moon Lambo blessing, as if that means anything. But this is going to be this is impactful, and this is going to be the most important case that you could possibly imagine in crypto, frankly, moving forward. Because think about this. Once this is precedent, it's precedent. So you can talk about future cases, like as they occur, future cases, fine, super duper important for XYZ reason, but this is setting the baseline here. So I don't know what's more important than that. It happened to be XRP first. Yeah, fine, there were other lawsuits, but not one that's seriously going to be precedent setting to this degree. This one really is that big. And so again, to have another party come in and back what attorney John Deaton's saying, hell yeah, that is exactly what we need. Now, as far as Billy Boy Hinman here, my gosh, this guy. Here's what attorney John Deaton had to say, and as I cited at the outset of the video, he is much more bold in the way that he's approaching this, and I understand why, and you will too. Just stick with me, go through this thread. You're going to enjoy it, and it'll express exactly why he's changed the way he's speaking about this from, hey, this is worth investigating, to, no, he broke the law. And there's, potential consequence there, because, Bill Hinman, there could be a defamation suit against John Deaton. He could file that if he wanted to. If he says this isn't true, he could file a suit. So John Deaton's opening himself up to that. And John Deaton knows that. And you'll see as we go through this thread, John Deaton's attitude basically is like, yeah, bring it. And you'll see why. Because in terms of the law, it's so clear to John Deaton that he's in the right, and that's why he's articulating this. So I'm going to share with you exactly what he says, and here it is. If he disagrees, so referencing Hinman, if he disagrees, he should sue me. Oh, wait, I'm sorry. That's the very bottom part. I knew that didn't sound right. Sorry, let me start at the top here. I didn't realize I hadn't scrolled to the top here. My apologies. Here's the top of it. So here you go, from attorney John Deaton. A year ago, I was hesitant and careful to not accuse Hinman of actually breaking the law. Like Charles Gasparino and Eleanor Terrett, I gave him the benefit of the doubt. Plus, you shouldn't impugn someone's reputation unless you have clear, irrefutable proof he/she violated the law. But see yourself. Hinman was warned by SEC ethics that he was barred by the Financial Criminal Conflict Statute from engaging in any contact with his partners at Simpson Thacher. What everyone needs to understand is that this was a strict, absolute prohibition. And I'll pause to note for those of you not looking at the screen, he capitalized strict, absolute prohibition, and he did that for a reason. John Deaton continues. What this meant was absolutely no contact, and that's in all caps too. No emails, phone calls, lunches, or meetings where his law firm would be present. Now, folks, I have talked about this concept before, but please let that sink in. There is to be no contact. Did I make myself clear, damn it? No emails, no phone calls, literally nothing, no lunch meetings, anything. But Bill Hinman is above the law, he seems to think. I mean, the arrogance of this man is stunning, but this is what you see again and again from officials at the SEC. The level of arrogance, the degree to which they believe that they are above the law, it's on display for all to see. You just have to look. So here's what Attorney Deaton has to say, and that points it up perfectly here. He says, the law makes it a crime for Hinman to have any contact whatsoever, because if he creates even an appearance of impropriety, it is a violation of the law. So pause to think about this. There doesn't even have to be actual impropriety. Doing things like, think about the appearances of impropriety in terms of, Hinman given the Ethereum free pass speech and how that might have impacted positively his law firm, Simpson Thacher. Set that aside. Even just the appearance of such a thing, just the appearance, that is breaking the law. That's a violation of the law. That's what Attorney John Deaton is saying here. And then Attorney Deaton says, from his SEC emails alone, we can prove beyond any doubt that Hinman met 3 more times after this stern warning. Imagine what we might find if we get to subpoena his private Gmail account or other account. And note right here, and this is somebody from the ethics office. I'll pull this email up. This is from January 25th, 2018. So earlier in the year before he gave the Ethereum free pass speech. This is from someone in the ethics office who wrote, in part, and this is an email. It's on your screen. I'm just going to read part of it. The analysis is the same for Simpson as it's always been. You have a bar under the criminal financial conflict with Simpson because you have an ongoing financial interest in the firm. Meeting with them while having such a conflict is not permitted. As we discussed during your briefing, even calls with them are not permitted. It's also a serious optics issue. You can't be seen to be granting special access to a firm you have a financial interest in. This meeting is small enough to raise concerns. There you go. So, pretty clear cut, right? But he doesn't care. He's above the law. He's Bill Hinman, flying in with a cape, saving the day, right? That's how he views himself, probably. And so, moving on a little bit further here, Attorney Deaton says, my God, the man agreed to meet on the same day a letter was sent from his division with his partner from China during the same time the Division of Corporation Finance was discussing approving the IPO of Cannon, a manufacturer of Bitcoin and ETH mining equipment. So think about this. And I'll pull up the screen grabs that Attorney Deaton shared. Here's the first one, so you can see Cannon being referenced August 19th, 2019. Okay, so it's the Securities and Exchange Commission. You get the letterhead at the top there. Then you can flip to this. And here are emails, also from August 19th, 2019. And this is Chris Lin, a contact of Bill Hinman over in China, and which reads as follows. Hi, Bill. I don't know whether you have received my email below. Please let me know if I can come by to say hello in the afternoon of August 22nd, Thursday. Thanks. Best regards, Chris. And you can see the response from Bill Hinman on the 19th. Sorry, Chris. I thought I had sent a reply. Should we get a cup of coffee around 3? Bill. So all this is happening. Do you see the conflict there? So the meeting with them, here's this firm, equipment for Bitcoin and ETH, and then his firm, a member of the Enterprise Ethereum Alliance. These are facts. These are just facts. This isn't speculation. These are facts. And then Attorney Deaton says he was a profit-sharing partner while he was declaring Bitcoin and ETH non-securities. For Christ's sake, He was receiving millions from Simpson Thacher, a member of the Enterprise Ethereum Alliance. At the same time, he gave ETH a free pass. Ask why the SEC is fighting to produce his emails and calendar. Pause, think about that. Because we know Judge Netburn has ruled more than once that the SEC must hand over all of the emails and drafts associated with the Billy Boy Hinman Ethereum free pass speech. Why is the SEC fighting so hard? Might it be for reasons in line with this? Who knows what the hell could be included? And I still think there's a good chance that somebody might have said, okay, but what about XRP? And even that's enough. Can you imagine even for fair notice events? Anyway, Attorney Deaton continues. Now that we have the emails obtained by Empower Oversight, and we've learned so much more, let me make it very clear without hesitation. As a former federal prosecutor, I can unequivocally state Hinman broke the law by violating the criminal conflict laws of the United States. Whew. If he disagrees, he should sue me. Of course, truth is a complete defense versus defamation. Anyone from the SEC who attempts to trivialize his violations is part of the problem. The man repeatedly joked about the conflicts. This especially goes for Gary Gensler and at SEC Enforcement Director, so that'd be Gerber Gruhl. That's the SEC Enforcement Director. So there you go. After having some time to let it sink in, and also new evidence came in to us, including Attorney John Deaton, after analyzing it further, he's coming out and saying very emphatically, yeah, Bill Hinman broke the law. And that's at a different level than saying this needs to be investigated. That is bold, and the evidence speaks for itself, does it not? I'll let y'all make your own determinations. It doesn't look good. I think that Attorney Deaton has made a bold position, and again, the stuff he's citing here, you tell me if I'm missing anything, looks like facts to me. Sure as hell looks like facts to me. And then there was this from Attorney Bill, member of the XRP community. He also read that thread from Attorney Deaton, and here's his take on it. He said, there is absolutely no chance he will sue you for defamation. He would have to discover the calendar, emails, his profit share arrangements, all of it, and it would suck in other people. The level of exposure would be huge and shocking. He just hopes the storm blows over. So there you go. That's an interesting take, and it's probably correct. I wouldn't be surprised, right? Would you? Billy Boy Hinman just wants this to go away. And Attorney Deaton, again, I mean, it's not like, if anything Attorney Deaton said there is not true, you tell me what's not true. I'm not seeing it. If something he said there is not true, tell me what factually is incorrect, and I'll talk about it on the channel. Please tell me. Seriously, I mean that. I'm not seeing anything. I'm seriously not seeing anything. And I appreciate these scumbags at the highest levels of the SEC getting called out. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.